Supplementary cause list, item number 1 for pronouncement of judgment.
You are in this case also? Yes. You did not make any submission, so I did not record anything.
This I have given as per my this affidavit only.
Okay, what is it? You have nothing for you.
It's this whatsoever my affidavit, more than this I don't have anything else.
Okay, I'll read only the portion.
Only if my name is coming, then it will be alright.
Your name is there. In view of the above, this court need not dwell on the issue of res judicata or any other irrelevant issues or even judgments or decisions cited by the parties herein. Since, on an overall consideration of the case, it is found that the petitioner and the members of his association have not been able to make out a case for issuance of any mandamus by this court. Petition is devoid of merit, hereby dismissed. Thank you. A very tricky case. Issue policy matter is there. Oh, perhaps on that ground. Thank you. The parties are you're aware, no, of the fractured.
Yes, my lord.
Lord.
Hardly only three or four matters are left, if your lordship.
Somebody was saying that you wanted to go for a picnic, so
No.
most probably you'll ask for time.
Yeah, she says item number 4.
Mention.
Please, Your Lordship, I beg to mention item number 4 of the hearing list, my lord. Name of the parties is Nathaniel John Dexter Shaddap.
Yes, 4.
Cons of 4. There's a separate list of 4.
After deduction is under.
Original item 10, my lord.
Yes.
Original item 10.
You've got a.
Lordship, it's been re-endorsed. I've just received the file
Have
yesterday.
you got a new cause list with you?
No, my
No,
lord.
my lord. We just inquired, it's item number 4 as per the new cause list. We were informed.
We'll go by the old cause list.
Lordship, then in that case it will be 10.
Because 4 is in the order.
Lordship.
My lord.
So item number 10 of the hearing list, my lords. It's been re-endorsed, my lords. I've just received the file yesterday. If I may just pray for 2 weeks' time.
1 to 5.
Pray for the respondents, state respondents 1 to 5.
On premiere by the.
Let it be 4 weeks.
You're the petitioner. On premiere by the parties, this is not up to 4 weeks.
Deeply.
Highly pledged.
Your Lordship, may I please beg item number 13 to come up?
You're for
Petitioner.
petitioner.
I'm for respondent number 3 and 4.
Who's for the state?
No, Judge.
Mr. Sengupta was
He might be in the other courtroom, Lordship.
How long?
2 weeks, Your Lordship.
No objection.
On premiere by the petitioner, not objected to by respondents. This is matter to 2 weeks.
Much obliged.
Is Mr. Manta okay now?
He's doing better. He'll join the court after 2 weeks or so.
Your Lordship, I beg to mention item number 2.
Number?
Number 2 from the supplementary cause list. I'm on behalf of respondent number 1 and 2. No objection, my lord.
This is a 2017 matter. on pre-made by the respondent. This is matter after 1 week. 1 week.
Highly obliged. May it please your lordship, I beg to mention item number 18, my lord.
Well, since you have asked for time, otherwise the new roster would show that this matter would not be before this court. Even if I take up the hearing today, it will not be proper. I don't think we'll be able to do today, but
What about the other two matters, my lord?
perhaps, I don't know, because anyway, the only thing is, I believe, if I remember correctly, all these matters would go before the Justice Charji. If at all he recused, then it comes back for any other reason. So for the time being, we'll put it off after 1 week.
2 weeks, my lord.
2 weeks.
I'm not here next week.
On pre-made by the parties, this is matter after 2 weeks.
Great.
I'd like to mention item number 17, Your Lordship. Daily, Your Lordship, hearing.
You are for?
For the petitioner, Your Lordship.
Yes, Miss.
Lordship, let this matter be.
No objection, my lord.
This matter comes out of 2 weeks, Lordship, because we're still not in position to argue this matter today, Lordship.
On pre-made by the petitioner, this is matter after 2 weeks.
Much obliged.
Much obliged, Lordship.
Daily causes item number 4.
Lordship, there was supposed to be a meeting as per your Lordship last order. So the meeting held, Lordship. But unfortunately, Lordship, they were not cooperating with us. They came to us, but the way they are making submission as if they are alleging us. So at the end of the day, when after everything happened, and for me to prepare the meeting minutes of the meeting as a report, actually I burnt my hand, so I could not prepare. By Monday or Tuesday I'll prepare it. So but for the minutes of the and there, what happened when they came, they were with that mind that they are not going to deposit that amount. So and they were alleging us repeatedly that we are not.
You see, what is required, I think this court has rather requested the parties
Yes, yeah,
to
got you.
find out a middle path,
Yeah, amicable solution.
so that you can, if there's any, it's a question of give and take.
Yes.
The only thing is that this court is made to understand that the petitioner are not shirking their responsibility as far as payment is concerned.
Payment is concerned.
Now you will also be happy with that if they pay. Only thing is to to make some calculation, make some confirmation or adjustment as to what is due and what has been paid, because they have been saying that for certain years they have paid. Then it was again it was demanded from them. So those things you have to sort of, in any case this court cannot go into that.
Lordship, Lordship is absolutely correct. Lordship, we have in the petition, if you check, Lordship, after necessary calculation, Lordship, we have given them that revised calculation sheet. We have given them the revised calculation sheet, and as per the revised calculation sheet, we have deducted the amount also. Whatever is whatever they are supposed to pay, it comes to around 4 lakhs rupees. So they are now also challenging that they are this 4 lakhs rupees also they are not supposed to pay, and they are not covered under the what I got, because they were not cooperating. They were literally shouting. So I was present during the during the conversation. What I understood from them that they will not pay because the coverage tenure, they are not satisfied with that. It can be made more easier way also, but unfortunately nothing has come up in such way what we expected to, and what the court was expecting from them for their side. We are at the service end. We are supposed to render service to the public in general. So for that purpose only, like, it could not come to any finality of the stage. So they also said that they are ready to argue before this honorable court. So if they are,
then the matter would be heard. There's no way out.
there is
Matter will
no
finally heard, and if
But,
if this court finds that their intention is not bona fide, then whatever penalty
Because-
that is due, they have to. There's no
and
way out.
moreover, Lordship, the thing is that according to the EPF Act, actually this court has no power to try the first case at this instant, because
Okay,
the Act
there's
gives
there's
a
appeal.
provision
There's a provision for appeal.
for appeal, Lordship.
Then.
So this court at first instance, this can be an appellate court, Lordship, but at first instance
Okay,
this,
okay.
this court has no power, no
So
jurisdiction.
that also can be challenged.
That also can be challenged, Lordship,
Mr.
and
Dev, you are
Yes, my lord. I fairly, my lord, agree with what my learned senior has submitted. It appears, my lord, that the amicable settlement could not be arrived at for whatever reason. Here, my lord, the grievance why we approached this court was essentially the freezing of the bank account and the fact that we did not have any such intention to evade the due process of law, my lord.
but your conduct would belie that.
Of course, my lord. So what I am humbly submitting, my lord, that there was a direction, my lord, for them to file their affidavit, so they can raise the issues. We'll hurry and dispose it of, my lord.
I think that's the only thing.
I don't think, my lord, it will be proper to linger it for long, my lord.
I think that would be the best option.
Because if
because
the hearing,
after the Lordship, now the thing is that I would rather stress for hearing means affidavit I can file, but Lordship, it can be a short date may be fixed, because once the affidavit is filed, Lordship, we all know that adjournment after adjournment comes up. So this is an admitted fact.
very
Once
personal
the
accusation.
As far as Mr.
no, it is a fact of the court. I
As far
am
as Mr. Dev is concerned, he
Yes, it is always my endeavor, my
always
lord,
catch
to
him and then
lordship, yes.
we'll endeavor to dispose
Lordship,
it.
yes, my lord.
See,
Because the moment the dispute of amount comes, I have to go and appeal. There is no.
yes,
It'll be difficult for me to
this court,
maintain
see,
it. Yes.
Like I said again, if
Yes,
there are disputed questions of fact, even then this court cannot take it up.
Lordship.
And like you said, you see, if there's an alternative, forum,
Yes.
then naturally.
So let them file the affidavit, my lord. We'll here try and dispose it of.
Lordship.
Learned counsel for the parties. Ms. P. Bhattacharjee, learned counsel for the respondents 1, 3, has submitted that the parties have submitted that as directed by this court by the order dated 26/7/2023, have accordingly met on that date itself,
On second.
2/8/2023. However, there was no positive outcome from the proceedings of the said meeting. Without going to the details of such proceedings, the Learned Counsel has submitted that this matter may be finally heard on merits. To this extent, the Learned Counsel has submitted that the counter affidavit may be allowed to be filed. What about the state? you
For the bank.
Lordship, I'm for the bank lordship.
oh, you're for the bank? Okay. State is not here.
State is not here.
EPFO is a state
Bank.
authority.
Bank, we don't have much to say, lordship. It's between the two main parties.
Ms. Angela, learned counsel for the respondent 4 of the bank, has submitted that the bank has practically no role in this matter, but would await the decision of the court. In view of such submission made, let the respondent 1 to 3 file their counter affidavit with the next date fix. This is matter up to 1 week.